Hi, I'm David Freudberg, the host of Humankind. I actually grew up in public radio. I've been in the field since I was 16. And from the start, I was taught to offer people content that will inform and enlighten. This podcast is dedicated to spreading ideas that speak to the highest part of our listeners rather than lowest common denominator. If you like what you hear, we're asking for your help. Please leave us a kind review on iTunes so others can find us. You can also follow us on Facebook and Twitter. Thanks. Humankind is produced in association with WGBH Boston and supported by the Humankind Program Fund and a special grant from the Henry Luce Foundation.
I had these snow boots on. The snow was very high in New York. The streets were rather impassable, but I actually felt like I was flying to the UN that day.
The story of how an American diplomat, despite resistance, helped to launch an historic court to uphold human rights. You're listening to Humankind. I'm David Freudberg. At the end of World War II, the world's conscience was shocked when the horrors of Nazi depravity came into full view. Ghoulish scenes of concentration camps surfaced for the first time. And this coincided with another remarkable development. War crimes tribunals in Germany as well as Japan placed the perpetrators on trial for their crimes. Legal rules at the time were imperfect, criticized by some as one-sided victor's justice. But the Nuremberg and Tokyo trials were widely viewed as an important step. They asserted the rule of law and human rights after dark years of chaos and barbarism.
I think it's a certain catharsis for the victim to come to court and to testify. He or she gets it off his chest.
Gabrielle Kirk MacDonald, a former U.S. District Court judge, presided over the UN tribunal for the former Yugoslavia in the 1990s.
It allows them to go forward and lead their life in a better way because they feel like, and again, it's my opinion, they feel like that they're part of a system that responds to crimes not by committing more crimes, not by meting out vengeance, but by the application of the rule of law. So I think that encourages them to go back, perhaps, to their own community and say, you know what, maybe there's another way.
It was very important that they be put on trial for the future, for all of mankind. And it's important today that we realize this.
The late Walter Cronkite, longtime CBS News anchor, covered the Nazi trials in Nuremberg, Germany as a young journalist.
If we are to have a lasting peace in the world, we are going to have some system of international law and order. We're going to have to yield some sovereignty to do that. All the nations of the world will have to do that, yielding up to an international system of order and law. The importance of Nuremberg was it did establish this precedent for this kind of legal action and this kind of court.
But when the World War II tribunals completed their prosecutions, many observers felt this left a legal void. If new war crimes were committed, temporary courts would have to be started from scratch, with little continuity or institutional stability. So for decades, a determined band of human rights advocates pressed for creation of a permanent tribunal to prosecute the worst crimes.
Ladies and gentlemen, I have the honor to declare open this United Nations Diplomatic Conference on the establishment of the International Criminal Court. I invite the participants to observe 1 minute of silence for prayer or meditation.
Rome, Italy, July 1998. UN Secretary General Kofi Annan attended a gathering of nations where the treaty for the new court was formally adopted.
People all over the world want to know that humanity can strike back that whatever and whenever genocide, war crimes, or other such violations are committed, there is a court before which the criminal can be held to account, a court that puts an end to a global culture of impunity, a court where all individuals in a government hierarchy or military hierarchy, without exception, from rulers to private soldiers, must answer for their actions.
The Rome Treaty envisioned a human rights court system that would operate in The Hague with judges and prosecutors appointed from around the world. But the court would have jurisdiction over only nations that ratify the treaty. When the required minimum of ratifications was reached in 2002, the International Criminal Court came into effect. The first step toward full ratification is for a nation to sign the treaty, which indicates basic support. But with many American conservatives skeptical of the new court as a potential runaway train that could restrict military decisions, obtaining U.S. signature was a bold step. David Scheffer served as the State Department's ambassador for war crimes issues under President Bill Clinton. He recalled the events in a recent memoir, All the Missing Souls.
On December 31st, 2000, only 3 weeks away from the end of the Clinton administration on January 20th of 2001, I boarded an Amtrak train in Washington very early in the morning to New York, and the reason at least why I was on a train is we had a huge snowstorm in Washington, and the planes were not taking off. So I had to get to New York. Why did I have to get to New York that morning? Well, it's because President Clinton was at Camp David, and for several days he was examining the pros and cons of signing the Rome Statute to the International Criminal Court so that the United States would at least be a signatory nation. That doesn't mean it's a ratified nation. That requires Senate approval, for ratification of a treaty. But the first step is signing it.
Which signals an intent to consider ratification.
Yeah, exactly. And President Clinton had to decide whether or not that was the last possible day to sign the Rome Statute under the terms of the treaties. After that, you could only accede to it. And certainly it was my judgment, being the top negotiator for the U.S. government on this treaty, that we needed to have that credibility as a signatory to actually prevail to protect U.S. interests in the treaty regime. Fully realizing that ratification was many, many years off in anyone's dreamland, for this treaty at that point.
A powerful voice objecting to the U.S. ratification of the treaty was Jesse Helms of North Carolina, who died in 2008. He was an arch conservative who once led a 16-day Senate filibuster to prevent Martin Luther King Day from becoming a federal holiday. In the year 2000, Helms chaired the Senate Foreign Relations Committee.
Now, the court's supporters argue that Americans should be willing to sacrifice some of their sovereignty for the noble cause of international justice. Well, then, international law did not defeat Hitler, nor did it win the Cold War. What stopped the Nazi march across Europe and the communist march across the world was the principled projection of power by the world's greatest democracies. And that principled projection of force is the only thing that will ensure the peace and the security of the world in the future.
With strong pressure from the Pentagon against signing the International Criminal Court Treaty, and as President-elect George W. Bush prepared to take office, Bill Clinton faced a stark choice in the final weeks of his presidency in late 2000. Former Ambassador David Scheffer. President
Clinton had not made up his mind by the morning of December 31st. And remember, by midnight of that day, there's got to be a decision. So I was instructed, get on the train, and maybe by the time you get to New York, he will have decided. President Clinton was a tremendous fellow, and still is, of course, very brilliant. He does make decisions at the last moment. And so I got on the train, and while I was on the train, I was communicating constantly with my colleagues at the National Security Council at Camp David, working through contingency drafts of statements and the whole slew of work that you do when you make a major decision of this nature. Well, when I got to New York, I was going up the escalator at Penn Station, and I had my snow boots on. It was snowing. It was, just terrible outside. And as I was ascending the escalator, I got a call on my cell phone from Secretary of State Albright. And she told me, well, David, I'm very pleased to inform you that the President has decided that the United States will sign the Rome Statute of the International Criminal Court, and you are hereby delegated, with plenary power to go to the UN and sign for the United States.
What was that like?
Well, it was a great moment for me because I had fought 8 long years for this, and frankly, as the book describes, there was a time after the Rome Conference in '98 when I was sort of a lone voice within the U.S. government, even to go back into the follow-on negotiations for the Rome Statute. So it had been a very, very long journey, and as I write, I had these snow boots on. The snow was very high in New York. The streets were rather impassable, but I actually felt like I was flying to the UN that day. Mm-hmm. So it was a good moment for me.
So after that dramatic scene, how did you feel when in 2002 President George W. Bush signed the American Service Members Protection Act, mm-hmm. which exempts U.S. military personnel from prosecution by the International Criminal Court?
Right. This is a bill that had been sponsored in the year 2000 by Senator Jesse Helms of North Carolina and Congressman Tom DeLay of Texas. And we had vigorously opposed it in the Clinton administration, and I had lobbied many members of Congress to just kill this thing. And we succeeded. But of course, when the Republican administration came in, it became a very attractive bill and was put forward again by those two individuals, Helms and DeLay, and certainly fit in to the overall, I think, concept of President George W. Bush's approach to international justice and foreign policy. So it was a very difficult moment because it was a reversal of our leadership in international justice. And I think history now shows how destructive that act was in 2002 with the American Service Members Protection Act, which, by the way, is still law in the United States. It has not been repealed. However, its punitive provisions have all been repealed by Congress, namely that it was designed to punish other countries that join the ICC.
The International Criminal Court.
Yeah, the International Criminal Court. And punish by withdrawing economic assistance, economic support funds, by shutting down bilateral military programs. Well, through the years, of course, that works against U.S. interests. And even the Pentagon said, for gosh sakes, would you repeal this? Because you're destroying our mill-to-mill relationships with so many countries, because they're not going to walk away from the International Criminal Court. They are walking, in fact, they're charging towards it.
We are discussing human rights and the historic creation of the UN's International Criminal Court. You're listening to Humankind. I'm David Freudberg. For more information on this segment, Upholding Human Rights with David Scheffer, please visit humanmedia.org. The vast majority of the world's nations have now joined the International Criminal Court, becoming what's known as states parties. These include England and nearly all of Europe, Canada, all of Latin America, Australia, much of Africa. But to date, the big powers, including the United States, Russia, China, and India, have not ratified the treaty, nor have most nations in the Middle East, including Israel. Efforts to promote U.S. ratification of the court treaty have long met with stiff resistance from the Pentagon. Former U.S. War Crimes Ambassador David Scheffer is author of All the Missing Souls.
The concern by the military is that situations could arise where American soldiers are operating on the territory of a state party to the treaty, and if the atrocity crimes that fall within the jurisdiction of the court are committed by American soldiers on that state party territory, then there is the strong possibility that American soldiers would fall within the jurisdiction of the court because they're operating on the territory of a state party to the court. And that, of course, goes against the grain of any exposure to a court of this character unless we're actually a party to, the treaty of the court. So there's that basic objection right there. But I think the larger one is, and it's a little more conceptual, is that there's a great fear that the potential liability of the U.S. military under the Rome Statute, whether we're a state party to the court or not, would tend to unduly influence the actual making of foreign policy, the actual making of military policy, because we'd always be looking over our shoulder to calculate our liability before the court before finalizing the plans for a military operation. And the military, of course, don't want to have that impediment in their thinking.
But considering the content of the crimes that the court has jurisdiction over, war crimes, genocide, crimes against humanity, aggression, why would it be such a bad thing for military leaders in the United States to have to be looking over their shoulders at the potential for legal liability for such crimes?
Well, that has quite often been my argument, and I think I express it at one point in the book because I truly believe, that surely the United States is not in the business of planning and executing genocide or undertaking the kind of massive policy planning required for crimes against humanity, ethnic cleansing, etc. Remember, in order to prove or in order to indict before the court, the prosecutor has to demonstrate that he or she has identified the criminal intent of the perpetrator, of the leader that he's targeting. And that's very difficult. And you have to imagine that if the United States has military or political figures who literally exercise criminal intent to commit these massive crimes against civilian populations, actually they really should stand to account for it before a court of law. Ideally, it would be an American court of law. But we have to say to the world that we certainly stand for that proposition, that they must come to justice, individuals who have the criminal intent and then exercise it with respect to these types of crimes.
The Financial Times recently reviewed your book. It said no country has done more to create an international justice system than the United States, or to keep itself outside the reach of that system. Is that fair?
Yes, it is. That was a review by Professor Philippe Sands at the University of London, and there's a lot of truth to it. And of course, that was the complexity of so many of my negotiations in the 1990s. And I think the book sort of goes over that ground fairly extensively, in that I was quite often in the paradoxical situation of pressing hard for the logic of credible justice for the commission of these crimes on foreign lands and by foreign perpetrators, and yet having to sort of always make sure my backside was covered, in that I wasn't bringing this concept to the shores of America, you know. And
was that awkward for you?
oh, of course it is. You know, some of my European colleagues in the negotiations had a much easier time at it because their countries or their governments were not, shall we say, so intimidated by the prospect of themselves being held to account. They had already gotten used to the European Court of Human Rights and the European Union institutions, and the Latin Americans were used to the Inter-American Court of Human Rights and the Inter-American Commission of Human Rights. I mean, there were lots of things where they knew that there was a, shall we say, a supranational body that actually looked at human rights issues and dared to lecture them about it. Whereas for the United States, we haven't had that experience. And so particularly, but of course there's a huge difference. The United States has a globally deployed military far in excess of everyone else. And so therefore the Pentagon, and I think sometimes very justifiably, has concerns about, well, look, we're globally deployed. We need to ensure that that's done in a way that protects our interests and doesn't unduly subject our soldiers and commanders to unwarranted claims of criminal intent, etc. And I always use the word unwarranted because I said, I'm happy to negotiate anything that insulates us from unwarranted and unfair allegations. I'll be there every day for you. But, if it's actually a credible allegation, if it's actually something that we don't have an immediate defense to because maybe something did go wrong, don't ask me to negotiate immunity for you. First thing I'm going to do is insist that you get prosecuted in the United States. And if there's resistance there, then we should take a look at where at the end of the day are you held accountable for these crimes. So that was sort of a tension, and I wasn't the best friend of the Pentagon through all of this. But that's the nature of bureaucracy and of governing, as you have these debates internally.
David Scheffer is now a law professor and director of the Center for International Human Rights at Northwestern University. In 2012, the UN Secretary General appointed him a special expert to the Khmer Rouge trials in Cambodia. In the 1990s, he worked for the U.S. State Department and the White House National Security Council.
The first court we built was the Yugoslav Tribunal, the International Criminal Tribunal for the former Yugoslavia in 1993. And
in The Hague.
In The Hague. And that has jurisdiction over all of the republics of the former Yugoslavia, which includes, of course, Serbia and the lower part of Serbia, which is Kosovo. And even Macedonia is part of that jurisdiction. Well, of course, when we set up the court, we were looking at all these atrocities occurring in the Balkans and how to get a handle on that and bring the perpetrators to justice. And, of course, it was not Americans doing any of that. But when Kosovo came along, we had a bombing campaign of both Kosovo and Serbia, a NATO bombing campaign that was part of the resistance to the Serb assault on Kosovo. And the prosecutor of the Yugoslav Tribunal, under pressure from various groups, opened up a file to review the legitimacy of the bombing campaign under the law of war and international humanitarian law. And when this became known, because usually an informal review is a secret process within a prosecutor's office, but the prosecutor herself kind of blurted it out to a reporter one day.
Carla Del Ponte.
Yeah, Carla Del Ponte. And, of course, the moment that hit the newspapers, suddenly it became known to my bosses at the White House, et cetera, that we were under review, by the Yugoslav Tribunal, the court that we supported so strongly. And I write about how the National Security Advisor at that time, Sandy Berger, I had to fly back to Washington from a reasonable Christmas vacation to kind of peel him off the ceiling because he was so angry that the United States was being subjected to a judicial inquiry by the Yugoslav Tribunal. And I explained to him that actually we had known this was on the prosecutor's desk since last May, 8 months earlier. It was very normal. People lodge complaints to the prosecutor. She takes them in. She figures out what's going on. It wasn't that big a deal. But there was automatically sort of the sense of resisting the prosecutor in her examination of these matters, and she needed our cooperation to get all the facts and understand, what was the targeting decisions, et cetera, of the military. And for months, I had to work that issue very, very hard within the bureaucracy to ultimately sort of open up that cooperative relationship with the tribunal to say, all right, what are the 26 bombing hits that you are scrutinizing? Okay, what are your questions about each one? Let's answer those questions. Did we properly plan for each target? Did we understand where the civilians lived, et cetera, et cetera?
So a degree of accountability.
A degree of accountability. And, it takes homework. You got to work it. But at the end of that process, the prosecutor determined that there was not enough evidence there to sustain a charge of violation of the law of war.
Since formally beginning its work in 2002, the International Criminal Court has received complaints from well over 100 countries concerning alleged crimes to be investigated. The prosecutor is looking into allegations in Latin America and Asia, but to date has focused prosecutions relating only to Africa. In April 2012, Liberian President Charles Taylor was convicted of war crimes and crimes against humanity at a trial held at the court under auspices of the Sierra Leone Tribunal. But has the court's role been muted because the world's most powerful nations have declined thus far to participate?
It's a reality that if you had these other powerful states as part of the court, it would just give the court a tremendous additional boost of credibility in the international community. It would demonstrate to the tyrants and others who unleash these crimes that actually they're in the extreme minority as to the legitimacy of doing so and of their capability to continue to do so, because the major powers are on the other side of the fence, and they're not open to geopolitical strategizing to respond to these atrocities. They're actually within the four corners of the Rome Statute, and that means one initial line of response is retribution, judicial retribution. You will be held to account in a court of law for the commission of these crimes, and guess what? The most serious sentence is life imprisonment. So, welcome to the halls of justice. I would like to see the United States on that side of the fence, obviously, instead of anyone presuming that they could deal with us in some sort of manipulative fashion to avoid accountability.
Former U.S. Ambassador for War Crimes Issues David Scheffer. He is author of All the Missing Souls. You're listening to Humankind. I'm David Freudberg. Studio recording by Antonio Liart Rose. Editorial assistance from Thomas Royal and Kathy Graham. Webmaster Brian K. Johnson. Special thanks to Tony Buck. Our program is produced by Human Media in association with WGBH Boston. Program development provided by Shart Media.
To purchase a CD copy of this program, please call 1-800-5LISTEN. That's 1-800-5LISTEN. Or visit our website, where you can also obtain an audio download of this and our other programs and can hear selected episodes free. You can access free written materials related to this program as well. Our web address is humanmedia.org. Again, if you'd like to purchase a CD copy of Humankind by phone, please call 1-800-5LISTEN, and our web address is humanmedia.org.
This segment, Upholding Human Rights with David Scheffer, is Humankind Program number 180.
The executive producer is David Freudberg. This is Humankind.
To hear more episodes of Humankind, you can subscribe to our free podcast on iTunes, Stitcher, or your preferred podcast player. A new episode each week. The podcast title is Humankind on Public Radio. And if you enjoy this program, be sure to leave us a kind review at iTunes and Stitcher. If you want to support the program, please visit humanmedia.org. And at the top of the homepage, click on How You Can Help. Again, our web address is humanmedia.org. Thanks.